All right, so David John Walter Petition of Right, prima facie evidence and its forensic document, page 81 to 90. Now this is going to be very interesting part, and David did send it to in 5th of June 2020. I placed the submission in the form of petition of right, which was addressed to the Chief Justice of the High Court of Australia, Susan Kiffel. She's still the Justice, to fully examine the documents that I attached in evidence. Now, when Justice, because she's not a lawful judge, when Justice Kiffel was contact Your Majesty, so basically when you send this document, she has the duty of care to contact the Queen and or right now the King, and present these documents and her findings and the results of the private examination. Now, Justice Kiffel AC is also a shareholder in the company and believe the Justice Kiffel AC. Justice Kiffel AC should have contacted Your Majesty the Queen personally and had the matter resolved to the very serious nature of this petition of right. And Justice AC has the same petition of right that was also granted to her by us, the people, the common company, including yourself as a Speaker in House of Representatives. So I also forwarded a copy document electronically to the Registrar of the High Court of Australia in Sydney to give a copy of the document to Chief Justice Kiffel AC. That was after I spoke to Registrar in the High Court in Canberra by telephone. Basically, what's happened, I have not forwarded, so that was Sydney Registrar, was a reply that was Adam Griffin. I have not forwarded your document to Chief Justice, nor will I permit such a formatting any form by any means. Why? Because this is exposing the fraud, and if they actually file it, they got a duty of care to rebut it, and that's the reason they didn't accept it. Okay, so this is the David John Walter petition of right. There is a proof of evidence back 2 years ago. We're talking about High Court of Australia in Sydney, and Adam Griffin, Deputy Registrar, he's still there. Now, and then he, then again from the registrar, right? The only information that can be given to refer you to the forms and procedure requirements set out by the High Court Rules 2004, which can be obtained online. Okay, so High Court of Australia Act 1979, it's a private act, fraudulent seal, no contract under the seal. It was introduced in 19 October 1973 with the Royal Style and Titles Act. Remember this document which I am, putting through on YouTube, and the reason why I'm going through like the main points I want to point it out, and this is very important and it's very serious, because why the High Court did not file this document? What's the problem with this document? When is the put through nothing but the truth? Okay, because they need to rebut it. Then Statutory Rules 2004 as amended made under Judiciary Act 1903, Commonwealth Electorate 1980, Nauru High Court Appeals Act 1976, and High Court of Australia Act 1970, accomplished start date 11 of June 2001. An act repealing to appeals to the High Court from the Supreme Court of Nauru. This act may be cited as a Nauru High Court Appeals Act 1976. In this agreement means the agreement between the Government of Australia and the Government of Republic Nauru relating appeals to the High Court of Australia from the Supreme Court of Nauru that was signed on 6th of September 1976, being the agreement a copy of the text of which is set out in the schedule. The Chief Executive Officer of the Parliament of Australia, Scott Morrison, right now Anthony Albanese MP, is the current holder of the public seal of the High Court of Australia Act 1979, and the Registrar Adam Griffin, Justice Kiffel AC of the High Court of Australia Act 1979. Now, there are no elected judges in the High Court of Australia, no lawful judges, no lawful magistrate, as of 14th of February 1966, when the company ceased reading and legal tender of the company punch telling. The rules of High Court of Australia are hold to the Queen of Australia, head of the Commonwealth, holding the Royal Style and Titles, hold to the copy of the following for bring writ of summons to the High Court of Australia, holding a private Australian business number, and all applications require a fee in Australian decimal currency to be paid prior to acceptance and sealing with the seal of the Royal Style and Titles Act 1973, which is held by the Chief Executive Officer of Parliament Australian, Scott Morrison MP. Okay, so it's all there. Now, do you believe in democracy? Peter White. And there is the High Court, is a private court. Political parties are private Australian business known the Australian government, which consists only elected members of the registered political party, decided this, the private constitution of the registered political parties, and hold the authority of the private person and individuals only. The political appointed justice, not judges, are holding signed person-to-person contract under the seal, hold in signed seal de facto relationship with elected Chief Executive Officer, Prime Minister of Australia, MP Scott Morrison, and paid from the profits of the firm. The political appointed justices are charged with authority only Chief Executive Officer of the Australian Government to uphold the philosophies and the policies of the Australian Government and to protect the firm and the assets of the firm at all cost. All acts of the Australian Government are created and reprinted by way unsealed Statute Law Revision Act 216 of 1973 and hold to the public seal of the Australian Government affixed to the Australian Citizenship Act 1948 and finally is affixed to the Australian Electronic Transaction Act 1999. Then there is an explanatory statement of former Chief Justice, the High Court of Australia, Sir Harry Gibbs, Talbot Gibbs. I therefore have come to the conclusion that the current legal and political system in use in Australia and its state territories has no basis in law. Now, he used to be a former High Court member. I think he retired in 1985, and he wrote this letter in 1987. It's a 4-page letter. He is actually calling the system as a bureaucratic jungle, and he probably is very right. Now, this court case goes back in 2006, Burnsville State, Queensland v. Croton. And that was His Honour, if you believe in democracy, then you won't want an unelected judge deciding whether a law is a good law or bad law, will you? So this was His Honour, this was Peter White. And Mr. Wood, I will leave it at that, Your Honour. His Honour, I just find this outstanding. Soviet Russia would be proud of these laws. The policy itself, like perhaps many statements of government policy, were padded with philosophical statement. There is no need to refer to this so far as its application in law. In consent, the introduction as follow. Just to remember, Peter White, I think after 2 or 3 weeks after this court case, he was made to resign. Okay, so just tell you, how deep this goes, the stuff. Now, refer to the petition exhibit Prince Chief Justice of the High Court of Australia, Justice Susan Kiffel, page 3. I refer Your Majesty, His Honour, if you believe in democracy, that you don't want an elected judge deciding whether a good law is a bad law, right? Now, there have been no elected and sworn judges in Australia and paid in legal tender of the company Punch Sterling from 14 of February 1966. Every politically appointed judge or magistrate who have received the private salaries and allowance Australian decimal currency, the private property or registered political parties. In the Australian Government, the private Australian business now registered on the New York Stock Exchange and hold a private contract under the seal with the political parties only. I bring to this personal attention of Your Majesty the Queen, as you are the owner of the 187 ton of gold holding a Royal Australian Mint. It is only you who can lay and bring criminal charges, if any, against those who sold the gold from the Royal Australian Mint in Canberra. Okay, so they sold the gold. Where is the money? Now, Mr. John Howard, MP Prime Minister of Australia, holder of the private seal of the members of the Australian Government, holder of Australian Citizenship Act 1948, as holder of Royal Stallion Titles Act 1973, and Corporation Act 2001 and Defence Act 1903, and entered into private partnership, the willing and declared war on the people of Iran and the leader Saddam Hussein, known as a war of terror. So then it's again the people in Iraq and Saddam Hussein did not declare war on the people of the Commonwealth of Australia. Inside the preamble, it's all organized anyway. Then we go back to the Statutory Revision Act, Revision Act 1966, the decimal currency. Then we go to the Statutory Law Revision Act 1973, which is hold no seal, no royal assent on any Queen of Australia holding royal stallion title. Queen of Australia is fraud. Okay, so it's a foreign corporation registered in America. Then it goes to the Statute Revision Act 1973 for the purpose of statute law. Then there is of 1974 and there is no letters patent. The Governor General is gone. Then so that's how they should be paid. Pound sterling in pounds. This is in the Constitution Act 1867. Okay, and you can basically look it up, and they should be paid in pound sterling and pounds. If you are in Queensland, the Constitution Act 1867, Queensland. If you are in New South Wales, the New South Wales Constitution Act 1855. If you are in Victoria, Victorian Constitution Act 1855. Okay, so Any person fraudulently impersonates represent himself to a member of the defense force with the intent to obtain free convenience and by railway or tramway or to evade payment for any toll or due shall be liable to penalty not exceeding £10. Okay, so this is the Defence Act 1903.